As we learned last night from the BVIAC President, John Beachy, Dawn Smith is a force of nature who will not be denied, and she has fully empowered her colleague Francois Lassalle. So it was impossible to refuse. After all, we do know what happens when an irresistible force meets an immovable object. This opening panel will appropriately address the vision of the BVIAC to become the international arbitration center of choice to meet the rapidly evolving dispute resolution needs of arbitration users worldwide. And we can't possibly begin to realize that vision without first building an arbitration culture in the Caribbean and Latin America. Dawn Smith has, by her relentless pursuit of excellence in all things, blazed the path for the BVI towards that vision. Judging by the number of globally recognized arbitration experts gathered here this week, she's clearly doing something right. This morning, we have Michael Black QC, Arabella de Iorio, Natalie Reid, and beaming in from Jamaica, John Bassie. I will say a little bit more about each of them later, but first, Michael Black. Michael Black is himself another force of nature, though one of his earliest assignments was to dent washing machines in Harrods' basement so that they could be sold in a scratch and dent sale, as we call it in America. Described as a superb and seasoned professional whose cross-examinations are something to behold, Michael has incredibly practiced in the area of arbitration for 38 years. He is a widely published author and a highly sought-after speaker. We're extremely fortunate to have him present this morning on the rules governing arbitration, the growth of arbitration globally, and the role of centers such as the BVIs. Help me welcome Michael Black.
Well, again, good morning, everybody. For those of you who attended both Natalie's talk and John's speech last night, a lot of what I was going to say was covered already. So I intend just to go slightly off-piste or riff a little on what I was going to say on my slides, and really with more of the theme of what are the opportunities for BVI, which I think is a ball then I'll pass to Arabella later. I must say I do speak at quite a number of arbitration conferences, and often you find you're saying the same things to the same people from basically Sydney to Seattle. There's a sort of floating world of international arbitration professionals who seem to go from conference to conference. The joy of this conference is that we're in literally virgin territory, and opening up a new centre is very exciting. It's something I've been involved in other jurisdictions in the Middle East and in North Africa. It is a tremendous opportunity, and so I'm also assuming that people are perhaps not as familiar with international arbitration as other groups may be. So I'm going to, forgive me if some of the stuff that I deal with now is a little basic, but as I say, what I want to do is try and make it specific to what's going to happen in this jurisdiction, if I may. So first of all, I'd like to quote something John said in 2015, where he spoke about really the overwhelming advantage of international commercial arbitration was enforceability under the New York Convention, because there are some secrets that often arbitration professionals don't share. Arbitration is not necessarily cheaper than court, and it's not necessarily faster than court proceedings. It depends. Some tribunals, and it is a problem that we face in institutions, can take perhaps 12 months to deliver an award, particularly when you've got arbitrators spread across the globe in different time zones and so on. But the overwhelming advantage that arbitration enjoys over litigation is the New York Convention, as Natalie called it yesterday, the most successful of all conventions. And she also spoke about the map. Here it is. This is the world as seen through the eyes of the New York Convention. The dark color are the jurisdictions that have signed up, the 157 countries. So you can see, but for a swathe, really, of Africa, and one or two other outliers, the New York Convention covers the entire world. And you think about those of you who are litigation lawyers trying to enforce a BVI judgment in Saudi Arabia or in India, whereas enforcing an arbitration award from the BVI would happen even in Saudi Arabia, which is now beginning to enforce the New York Convention, and in India too. So that is a massive advantage. So I would define arbitration friendliness of a jurisdiction in upholding the New York Convention. And essentially there are three pillars, I would argue, for the New York Convention. So the recognition of arbitration agreements, in other words, the respect for party autonomy, for the choice of the parties to go with arbitration. Secondly, the enforcement of arbitration agreements by ensuring that where the parties have signed an arbitration agreement, the matter is referred to arbitration. And that was an issue that in fact came up in a case that I did before the Privy Council from BVI about 18 months ago, Anson and Hermes 1, where in fact both the commercial court here and the Court of Appeal did not refer the case to arbitration, but ultimately the Privy Council did. And without going into details, but for me it showed that there has to be maybe a slight adjustment of the mindset in this jurisdiction, and adjusting to the fact that if possible, you have to refer it to arbitration. The presumption is that it will be referred to arbitration, and I do commend the decision of the Privy Council in that case. You see the slightly different approach to agreed principles of law, almost, a policy approach. And then the third point is recognition and enforcement of awards. Awards will only be refused under very specific circumstances, and all of them really are procedural rather than substantive. There's no review of the merits. So you look at the capacity of the parties, or whether the agreement itself is not valid, notice of appointment of the arbitrator, whether the subject matter is within the clause, whether the tribunal is properly constituted, or whether the agreement itself is not yet binding. And those are the only defenses under the New York Convention. So wrong in law doesn't cut it. Merits wrong doesn't cut it. It's only really these procedural arguments that mean that there won't be enforcement. Now, there is a session, I know, that's going to be dealt with later in the conference on the CIR centenary principles, and I'm not going to touch them in great detail, and indeed John referred to them last night in his keynote address. But just to remind ourselves of them in relation to this jurisdiction, that there be a clear and modern arbitration law, that the judiciary is respectful of the party's choice of arbitration, that there's legal expertise within the jurisdiction, that there is an educational framework, and that there is a right to be represented by one's advocates of choice, that the place is accessible and safe, has appropriate facilities, that there is an ethical environment, that awards are enforceable, and that there is arbitral immunity. And that's a very hot topic at the moment. I spent a lot of my life in the Middle East, and at the moment the UAE has introduced a law whereby arbitrators can be the subject of criminal sanctions if they do not comply with the duty of impartiality and fairness. And interestingly, there is only one other country who has ever passed a law in along those lines, and I think it has been repealed subsequently, but it was Belize. But international arbitration is a complex interaction of different laws. So you have the law of the arbitration agreement itself, the which governs the actual agreement to arbitrate, the law governing the existence of the proceedings of the tribunal, sometimes called the lex arbitrii, the substantive law of the contract itself, and then we have the rules of jurisdiction, of institutions, and what's become increasingly known as soft law, guidelines issued by institutions such as the IBA, and then of course you have the law governing recognition and enforcement. So what is a modern lex arbitrii? And of course this jurisdiction is tremendously well placed in relation to that. It has the UNCITRAL model law, and I thought it was interesting just to put up on the slide the actual introduction to the UNCITRAL model law that you find on UNCITRAL's website, which says that it's designed to assist states in reforming and modernizing their laws, to take account of particular features and needs of international commercial arbitration, covering all stages of the process, the composition of the tribunal, the extent of court intervention, and it reflects a worldwide consensus of key aspects of international arbitral practice. So this jurisdiction has that. So it's covered point one with a vengeance. And just to look at the prevalence of the model law, here's another map, and there are 106 jurisdictions. In fact, that's wrong. There are, to my knowledge, 108 jurisdictions, because both the Dubai International Financial Center and the Abu Dhabi Global Market, which I say are probably my main jurisdictions, also have adopted the model law. So there are 108 jurisdictions in probably 76 countries that now have the model law. So just turning to the function of rules and soft law, a modern arbitral law will really give a framework within which the parties have the maximum flexibility to design their arbitral procedures to meet the needs of the particular case, while ensuring, of course, that they don't stray too far out of international norms so that the end result, the award, is not enforceable internationally. The rules and soft law are engrafted over that to facilitate the process, and parties are free to adopt the different sets of rules as they choose in their contract, and free often to adopt the soft law guidelines during the course of the arbitral process. So rules are generally made by institutions and they're named in the arbitration clauses, and it seemed to me that they deal with three fundamental things: the constitution of the tribunals and challenges, for example, to arbitrators, to deal with the financial matters, and to deal with quality assurance. The ICC, of which John, of course, was president globally, has what ultimately I have come to find a very reassuring procedure of quality assurance in the scrutiny of awards. I think as an arbitrator your initial view is you don't like having your award scrutinized, but actually when you work through it you do find it quite comforting and helpful, and I've become quite a fan of ICC scrutiny. So let's just deal with the growth of arbitration internationally. Again, John gave the figures last night. Those are the ICC figures that he referred to, but what was really interesting, and I think what I can add to what John said last night, is that last year 15%, there was a 15% rise in arbitration from South America, which I know will chime very much with what Natalie is going to tell us about Brazil. The Singapore International Centre is doing tremendously well, as is Hong Kong. And what is really interesting about Hong Kong is that after mainland China and Hong Kong itself, BVI is actually the largest user, if you like, of the Hong Kong International Arbitration Centre. So there is a business opportunity there. Chinese BVI structures are at the moment arbitrating in Hong Kong. Why don't they arbitrate here? That's something to think about. And then finally we have CTAC. CTAC is the mainland Chinese arbitration institution, and that is increasingly international, and of course again we will see the use of BVI entities within the international roster of CTAC. So turning finally just to look at the reasons for the growth of international arbitration, there is a regular study by Queen Mary University in London. Their 2015 study threw up some very interesting results. So 90% of the respondents said, and these were largely general counsel of international corporations, 90% of respondents said international arbitration was their preferred dispute resolution mechanism. They identified the enforceability of awards, i.e. the New York Convention, as one of its great attractions. They wanted to avoid specific legal systems. One knows that there is a great deal of business in this jurisdiction coming out of areas where the legal systems are not perhaps the most reliable in the world, so that's perhaps another selling point for this jurisdiction. Flexibility, as I mentioned before, and of course your ability to select your tribunal. They also identified established formal legal infrastructure. Well, we have that here. Neutrality and impartiality of the legal system. Again, we have that here. A national arbitration law. Well, we've dealt with that. And of course, a track record for enforcing agreements to arbitrate and arbitral awards. Well, this is a new jurisdiction. It needs to build that reputation. So I just wanted to add one thing, if I have 2 minutes left, literally, and it's this, about what I see as the real opportunities for this jurisdiction. There are two areas of work where this jurisdiction excels in terms of its legal expertise, and that's corporate law in terms of joint venture and shareholder disputes, and trust work. Dealing with the first, if I may, when I started my arbitration practice, which was now nearly 40 years ago, arbitration was really confined to shipping, insurance, construction, commodities, and so on. But it's changed in nature very much, and the majority of the work that I, certainly my colleagues do, now seems to be in relation to joint ventures and shareholder disputes. And there is a tremendous expertise within these islands in that area. Of course, given the fact this is one of the premier, if not the premier, company registry in the world. And of course that work has traditionally been done within the court system here, but there is no reason why it can't be done within arbitration, and therefore become even more enforceable and exportable into other jurisdictions. But it needs the support of the courts, because for me one of the disadvantages of arbitration, and it's hotly debated at many arbitral conferences, is the inability of arbitration to deal with matters urgently and to give interim relief. That's always been an identified difficulty. And so the courts need to do that. The courts need to support that. And these courts have massive experience in this jurisdiction of interim relief. And so I see a partnership between the courts of this jurisdiction and the arbitration community of this jurisdiction in building up and in reaffirming the expertise and fame of this jurisdiction in terms of JV disputes and corporate shareholder disputes. The other area which is really growing is trust arbitration, and something that I put on the table finally for this jurisdiction to consider is a reform of the arbitration law, or indeed the trust laws, to provide for trust arbitration. Many of the competitor jurisdictions have done it already. So my very good friend and colleague David Brownbill, who I'm sure many of you know, who's a great expert in trusts, sent me a list of the jurisdictions that have actually passed a trust arbitration law. Bahamas, Guernsey, Malta, Florida, Arizona and Liechtenstein. In addition, New Zealand has one on the books which is being proposed. In England and Wales, the Law Commission is considering it, and the ICC has a task force, of which David is a member, which is drafting a standard trust arbitration clause. That is another business opportunity for this jurisdiction. And I'll finish there, if I may. Thank you very much.
Thank you very much, Michael. Some very constructive words of encouragement and aspirational objectives for our brand new International Arbitration Centre. you'll be happy to hear that STEP BVI is actively considering amendments to provide for trust arbitration. Our next speaker, Natalie Reid, we heard yesterday and learned immediately of her passion for arbitration. As a partner of the International Dispute Resolution Group of Debevoise and Plimpton, Natalie is widely experienced in international arbitration, having spent some time in Rwanda and Tanzania in a wildlife park while she was part of an arbitration going on in Rwanda. Natalie is an associate legal officer of the International Criminal Tribunal. She is regarded as a rising star and has been described as a future leader, although I think she has already earned her stripes. Please help me welcome Natalie Reid.
Good morning, everyone. Thank you very much for that wonderful introduction. Following Michael Black is always a daunting position. I will do my best. Like Michael, we speak at a number of arbitration conferences, including actually throughout the Caribbean, where other jurisdictions, as we have heard in the past few days, are also considering launching international arbitration centers. In that context, there are always sort of discussions about what the model could be. What is it that you look to when you consider the path forward for a new jurisdiction looking to cement itself, introduce itself first, and then establish itself as an international arbitration center. And in that context, reference is frequently made to Hong Kong and Singapore, and for obvious reasons. What I think, however, is when you think of the topic of this panel, which is building an arbitration culture, practitioners in the Caribbean can look closer, and more recently, to Brazil. If you are thinking of an example of how a legal community can very consciously build an arbitration culture, it is my proposition, and hopefully by the end of my presentation you'll agree with me, that Brazil is an excellent blueprint. So let's start with why. So what have we seen in Brazil? The dotted line here is actually the average of a number of different statistical lines. If we measure what arbitration and the growth of arbitration looks like in Brazil over the last 2 decades, the components I have there in the bullet points. So it's the number of new cases administered by Brazilian institutions, and then unpacking the ICC statistics, which are quite rich, the number of cases and participants in ICC administered proceedings where Brazil is the seat, you have Brazilian parties or Brazilian arbitrators. So starting with the Brazilian statistics, with the 3 main Brazilian chambers, the arbitral institutions, and we'll talk about those a little bit later, the Canadian chamber, CCDC, which is linked to one of the main trade unions, and the American chamber, you have seen that graph. So the Canadian chamber, for example, had close to 0 arbitrations each year before 1999. In each of the last 3 years, they've administered more than 90 new cases. CCDC had 1 arbitration in 1998. In 2016, the most recent year for which statistics are available, it had 57. The American chamber, 1 in 2002, 103 in 2016. Turning to the ICC statistics, seated in Brazil, arbitration seated in Brazil, 0 in 1998, 20 or more in each of the last 3 years. Brazilian parties, 5 in 1998, more than 90 in each of the last 3 years. Brazilian arbitrators in ICC arbitrations, 0 in 1998, 71 in 2016. So let's figure out how Brazil got there. And picking up on the points that Michael highlighted, let's start with a strong legal framework. So if we try to figure out where each of these bumps in the graphs come from, we have the passage in 1996 of the Brazilian Arbitration Act, an UNCITRAL model law-based act. In 2001, that Arbitration Act was upheld against constitutional challenge. So again, you begin to see there's a little bit of uplift between the passage of the act and the confirmation that it is in fact enforceable. 2002, with the accession of the New York Convention, we begin to see, again, remarkable growth. In 2015, the amended Arbitration Act, essentially to clarify clarify some of the lingering questions in Brazil, primarily, for example, whether or not government parties and disputes involving government parties can be subject to arbitration. The next key component, arbitration supportive courts. So this is over the period between, in particular, sort of 2002, 2004, as Brazilian courts have gotten more experience with arbitration, you begin to see increased sophistication in the decisions. And it is, in fact, the hallmarks, as we've been talking about for the last couple of days, of a true arbitration-friendly jurisdiction. That you have pro-arbitration approaches, narrow and focused analysis to enforce arbitral clauses, recognition that arbitral tribunals can determine their own jurisdiction, arbitration agreements are severable, and then when it comes to the products of those arbitrations, for Brazilian seated arbitrations, interestingly enough, there are actually remarkably few challenges in the superior courts. And part of the theory is because parties know that the courts will generally uphold the arbitration award, so they don't spend their time challenging them as much. And in fact, you have this building jurisprudence, again, of firm support for arbitration. Interestingly, when we get to foreign awards that people then bring to Brazil in order to enforce them, you don't have a shyness in challenging. In fact, as you can see from the pie chart, only, I think it may be difficult, it's 14%, it's the dark red pie wedge there. Only 14% of the awards that were brought to, for enforcement in Brazil in this time period, 2008 to 2015, did the losing party not challenge enforcement. But of the, sort of the 86% that remain, a significant proportion were granted entirely, were granted partially, and only 12% were refused after the court reviewed. So we talked about arbitration institutions. We're also trying to figure out where some of the jumps of the graph come from. The CCDC, the Canadian Chamber, had been present in Brazil since 1979. And even though it is now the leading chamber, we can see as the additional chambers come in that they help to explain some of the support. But before 2002, with the accession to the New York Convention, the presence of arbitration institutions is not enough. And this is going to be one of the themes, that each of these has to work together. But it is important to note that you continue to get new arbitration institutions throughout this period. So again, it is a sign of continuing strength and deepening roots of an arbitration culture in the jurisdiction. The arbitration bar. So you have lawyers within who practice within the jurisdiction who view themselves as being part of a Brazilian arbitration bar. So again, you can see in sort of these key points where the graph is trending upwards. You have in 2001, that's the Brazilian Arbitration Committee. In 2011, that is the Student Arbitration Organization. And the two interim points there are Brazilian journals for arbitration. So again, these are all the hallmarks of a community that views itself not just as a particular flavor of legal practice, but really a specialist bar within Brazil. So this is, if we think of, sort of what's the framework that we have here, the infrastructure, so to speak. And then we get to practical questions. What are parties when they consider using arbitration? What are the push factors on one hand and the pull factors on the other? As we've heard in a number of talks over the last couple of days, one of the key driving factors across jurisdictions for resort to alternative dispute resolution, including arbitration, is an overburdened judiciary. I actually had my colleagues who helped me put together these slides triple check these numbers for me. This is the period between 2003 and 2015, and we see certainly increasing cases in Brazilian courts. The reason I had them triple check is that these numbers are millions. So in 2015, there are 74 million cases pending in Brazilian courts. Wow. Yeah. pause on that for a second. These are, of course, all cases, so it's not just commercial cases. They're in state, federal, and labor courts. But you could understand, if you are sophisticated commercial parties dealing in cross-border transactions, you are not going to want your disputes sitting in those courts. So if you're trying to understand where and why that statistical average line starts trending up, this is a major push factor. We can talk a little bit more about why there are so many cases pending in Brazil, but perhaps a little bit later. The pull factor. One of the reasons why, and one of the key factors for success, of course, of Hong Kong and Singapore is that they are major regional hubs for business, for commerce, for financial flows. And anybody, again, who's been paying attention to sort of the story of Brazil in the last couple of decades can understand there has been remarkable and incredible economic growth in Brazil. So this is between 1995 and 2016. So just the rise in Brazilian GDP, and of course, as many disputes lawyers know, particularly international disputes, sort of the larger an economy, the more commerce, the more transactions, the more scope for friction, and the more scope for international disputes. So if we combine all of these, this is what, so if we're trying to figure out what has both pulled the statistical graph upwards, and what are the key milestones that can help explain how we went, again, for Brazilian arbitration from close to zero to the remarkable success that we see now. This is combining all of the different points that I had talked about before, the legal milestones, the establishment of arbitration institutions, the push and pull factors. If we needed to summarize them in a way that perhaps a little bit more lawyer-friendly, less sort of graph-heavy. We have a strong arbitration institution with the infrastructure of both the support of both the public sector and the private sector. And again, each of these is insufficient by themselves. It is the combination of all of these factors and then pushed by strong demand. You can build the best mousetrap there is out there, but there has to be a reason for people to use it, and there has to be a desire for people to use it, and there has to be actually the pipeline of matters to generate the experience and the reputation that builds the arbitration center and the arbitration culture.
Good. Thank you very much.
It's quite interesting. I think what's quite comparable to the situation here, again, speaking from the Middle Eastern perspective, is the growth of financial centers that are seeking to act as, I mean, they are tax-free zones that have been established within various countries in the Middle East, one in Abu Dhabi, one in Dubai, one in Qatar, and now there's one in Morocco, Casablanca Financial City. And they've all taken slightly different routes in terms of dispute resolution. So, for example, Qatar, Dubai and Abu Dhabi have courts as well as arbitration centers, whereas Casablanca is looking merely to have an arbitration center within the overall judicial system of Morocco. But each one has focused on the importance of international arbitration to an international financial center that is trying to gather in business. Each one has sort of slightly different aims to the BVI in terms of what they're looking for, but they are competitors, both amongst themselves and both with the established financial centers in the Caribbean, BVI and Cayman, obviously. And it is interesting that they've identified the necessity for a strong arbitration culture to attract business into a financial center.
Absolutely. Arabella Iorio is known in the BVI as a fearsome litigator, but she describes herself as a boring person. I have no idea why, since she says her career guidance results during high school were that she should be a zookeeper. But perhaps as the senior partner and head of litigation in a major law firm in jurisdictions such as BVI, there might be some similarities. Arabella has agreed to come today to wrap up this panel discussion by talking about how we're building a BVI culture, a culture for arbitration in the BVI. Arabella.
Thank you very much. Good morning, everyone. I'm going to deal with two topics. I'm going to wax a little philosophical to start with, which is most unlike me. And then I'm going to try and address some of the scoffing that is going on, particularly about the future success of the IAC and whether it's a realistic goal to have. And I hope to persuade any remaining scoffers in this room after the presentations that we've heard to date that their scoffing is misplaced and unjustified.
Hear, 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 hear.
So let me start with this notion of a culture. We've been focusing obviously on the arbitration side of things. Well, but what does a culture actually mean? And in my research for the preparation for this session, I found that academic writers talk about culture in the legal context in two ways. And the first one, perhaps understandably, is very nationalistic. In other words, what are those aspects of a particular country's culture which filter into its legal system? So one might speak, for example, of the BVI having a common law culture when contrasted with some of the civil law jurisdictions. And arbitration can obviously start to feature here already as a nationalistic value. So there might be a country, for example, where it can be said there is a national preference for arbitration over, for example, litigation. Now, that's obviously not right about the BVI at the moment, and I don't necessarily think it's somewhere we need to be headed. There is an ongoing push for the revitalisation of other methods of alternative dispute resolution, and I'm thinking particularly of court-appointed mediation, which is enjoying a resurgence, and quite rightly so, under the auspices of Justice Ellis. But culturally, I would say, and I'm hoping not to be too controversial about this, on the international scene, we are known and admired for our international complex commercial litigation. Now, the second aspect of culture works in a completely different way, and that is it's a product of the community of professional lawyers who have a common training, a common expertise, and they engage in repeated interaction among themselves and with the legal system. And that produces a set of expectations which shape behaviour. So culture in that sense is a product of the law rather than a constraint on the law. And that's really where arbitration comes into the mix. And what happens, as we have seen, in an increasingly cross-national world, and we've looked at Michael's maps, is that the first set of values, the nationalistic values, come under a lot of pressure. And the increasing globalization that goes on produces culture in the second sense, because the group of professionals that's interacting is no longer just a national group. It's an international group of experts, and there's a much broader sphere. So the inevitable reality from all of that, I think, is that that second pressure has produced a massive increasing demand for arbitration. So turning then to the arbitration process itself, what's actually happening is the processes are becoming more and more streamlined across the jurisdictions. And that's very good for us. We can have a look at how the process has moved elsewhere, what have been the good points, what have been the bad points, what is it that the other jurisdictions can be said to be embracing as a group. And there are, I think, some threads that I can tug there. So, for example, the process itself tends to be a combination of oral submissions and written statements of a party's case. It's heavier, perhaps, simply on the written witness statement than the court process is, which is far heavier on cross-examination. There's a strong reliance on expert evidence, and all of that is subject to control by the arbitral tribunal, but not control to a degree that ousts the autonomy of the parties and the process that they themselves have contributed to choose. Generally speaking, the panel will be able to determine its own jurisdiction. That's the well-known principle of competence. And on the whole, the disclosure process is slightly more pleasant than the angst-ridden aggression of court discovery, which we all have to go through from time to time. And clearly, the roles of the model law and the New York Convention in this process cannot be underestimated, and they have been two of the greatest drivers towards this streamlining. So when we look at arbitration culture, it's a cross-border network, and as with all networks, one needs to compete for space on it. And that competition manifests itself, as one would expect, in the modernisation of law, the updating of domestic arbitration laws, and keeping a far more beady eye out for what the rest of the world is doing than we might have done previously. Now, scoff number one is to say, oh my goodness me, is this all justified? There's about one arbitration a decade. What is the point of all this effort? But that simply doesn't bear scrutiny. We've heard Natalie's story of Brazil, gone from zero literally to hero in a fairly short period of time. What you actually achieve is a conforming of your own arbitration laws and rules to those of others, hopefully with some nice domestic tweaks that make yours a lot more attractive than theirs without telling them that. And you encourage a body of domestic legal practitioners who have increasing expertise, increasing familiarity with the system, and an increasing cross-border ability to communicate with their colleagues. And finally, you hopefully have, or if you haven't, you can encourage a bench that fundamentally understands the arbitration process. And I want to emphasize that understanding. Yes, it needs to be a strong bench that can control, that can supervise, that can come to the aid of the parties with interim relief. But fundamentally, it needs to understand what's going on, that the arbitration process is very different, that the parties have chosen certain things they would like, and that those choices really need to be respected. And I think once you have that kind of landscape, and I think we already do, competition is encouraged. But what's also encouraged is more sophisticated negotiations between lawyers, more promotion of arbitration clauses in negotiations between business entities and business parties. And that inevitably results in more use of arbitration clauses, more understanding of them, more understanding of the process. It goes towards making arbitration easier, and something that is much easier for us to sell, and something that's much easier for us to excel at. That brings me to enforcement, and my co-panelists have spoken quite a lot about that. And I think domestic culture might on occasion militate towards scrutinising foreign awards more closely, particularly those, if I can put it without causing offence to anyone, from the slightly more suspect jurisdictions. But I think the reality is that enforcement with minimal review is much better, and it's much better both for the domestic economy and internationally. And of course, there's a quid pro quo. You're going to have a far easier time enforcing your own awards elsewhere if you're more welcoming to everybody else's. So to wrap up on the culture, a successful arbitration culture, in my view, should be facilitative, should encourage cross-border communication, and should involve a modern and efficient arbitral process. And I'm going to say we tick all of that. I'm going to come now to some more detailed scoffing. The second scoff on my scoff list is whether we're too late to the party. There's many arbitration centres. Some of them are IT-wise a bit more sophisticated than this one. A lot of them are larger. For goodness sake, who needs another one? But I think the answer is we're absolutely not too late. Isn't it better not to be the first person at the party? Isn't it better to arrive and you can take a quick look and see what everyone else is wearing and what everyone else is dancing to and what they're eating and drinking, and make sure that you do better than they do? And I want to actually pick a concrete example of that, and that's in the trusts arena, which Michael mentioned. And there's been a bit of a fierce competition over perpetuity periods, as some of you may know. So offshore trusts started out with the traditional royal lives in being plus X number of years that everybody was comfortable with. And then some bright offshore spark said, well, hang on a minute, I don't think that really caters to modern needs. Let's go for 99 years. That caused a great frisson through the offshore trust industry, and somebody else said, well, I think 100. I think 100 is actually far better than 99. It's a much better figure. Third person comes along to the party and goes, 99, 100, it's 150. Everyone's going to migrate their trust to my jurisdiction, it's 150. Then Miss Late to the party appears, and she says, God, you boring old lot. We're not going to have a perpetuity period at all. So put that in your pipe and smoke it. And there are a whole load of party goers in the Caribbean region who are a long way from, may not be able to get to a sparkly arbitration centre somewhere else, and to whom the BVI can provide the ideal solution. So we should be opening our party doors and welcoming them in. And I'm not obviously talking just about users of BVI companies, but users of other companies incorporated in the jurisdiction, in the Caribbean as a whole. We can open our party doors and welcome them in. Are our rules and our legal framework up to scratch? I don't want to be smug, but I'm going to say absolutely yes, they are. We have a modern arbitration act, it ticks all the boxes. We've got some user-friendly, bespoke rules. We have a model arbitration clause that, frankly, I'm finding it difficult to fault, which those of you who know me will find rather extraordinary. And as I've said, we obviously need to promote the use of BVI arbitration clauses. They're not just going to spring up like weeds. We're going to have to do some marketing, some selling. We need to promote the product that is this fantastic arbitration centre. And we do need to keep the rules and the framework under review. Because in today's use it and throw it culture, modernisation only lasts about 10 minutes, so we can't rest on our laurels, and we're going to have to keep a beady eye on whether our legislation and our rules are keeping pace. Now, what about our lawyers and our arbitrators? Is an international arbitration lawyer a special breed of person? Can we ever aspire to be such an amazing thing? And I've had two answers when asking that question. One really rather rude one said, well, they're just a stuck-up clique and they don't speak to anyone else. And really their only distinguishing feature is that they speak more than one language, and they don't forget to remind you of that every 5 minutes. I beg to differ. I'm going to go with the more positive view, which is that they are a group of professionals who think internationally. They avoid nativism. And their practices do possibly mean that they have more in common with their international arbitration colleagues across the globe than with their own domestic colleagues, but so what? It's a club we need to join. And that brings me to training. And the hurricane force that is Dawn Smith, I think, has recently launched yet another training session in the BVI, which is good news for me. I'm actually the chairman of the BVI chapter, and I find I just call Dawn and she says, oh, I'm so glad you've rung because I'm about to do X, Y, and Z. And I say, thank you very much, Dawn, and I put the phone down. So I don't want it for one moment to be thought that I deserve all the glory. I absolutely do not. Hurricane Smith deserves all the glory. Another scoff that has been raised, and this one perhaps a bit more vocally, is whether encouraging arbitration is going to cut the lunch of the traditional, in quotes, litigator, either because the local bar is going to get ignored, or worse, because even if there has to be a BVI arbitration, it doesn't actually have to be in the BVI, so what's the point of any of this? I actually see very little difference ultimately between litigation and arbitration as far as the local specialists are concerned. And when I look at the quality of lawyer, I'm heading towards the end of my 11th year in the BVI, there has been a cataclysmic change in quality. It used to be somewhere where people came when their conveyancing practices weren't doing so well in the provinces. And I think we can now safely say, when you read the law reports, that we've moved a very, very long way from there. And the reality is that in a big piece of complex international litigation, a local lawyer is going to be co-counselling with an onshore law firm. There are strategies to be implemented. There may well be litigation elsewhere that needs to be taken into account. That's how it works. It's going to work no differently in international arbitration. And I think the notion that Natalie is going to come in and not want to speak to anybody and sit in here running an international arbitration on behalf of Debevoise without having any interaction with the local bar is just pie in the sky. She doesn't want that. She doesn't want Debevoise to be running all the BVI arbitrations. Heavens, there's only one of her. She will want to partner with us. She will want to encourage and promote. And for our part, we have a lot that we can learn from her. The bench. And we've heard from Natalie that one of the factors that contributed to the growth of an arbitration culture in Brazil was the overloading of the courts. Now, that obviously provided an impetus in that country for a shift towards arbitration, because litigants were frankly getting absolutely nowhere. But it doesn't have to be that drastic. It's actually simply a question of being able to offer a choice. And surveys show that the parties' specific reasons for choosing arbitration are in fact generally procedural. It's global enforceability of the awards compared to enforceability of a judgment, the neutrality of the forum, and their ability to choose the arbitrator they want, the speed, the cost, and the flexibility of the rules and the process. And the BVI judiciary has in fact always, historically, been very firmly arbitration friendly and has been promoted as such. Parties are to be taken to have intended their disputes to be arbitrated, and arbitration clauses are generally upheld. Obviously, it took the Privy Council to actually get that into place in Anzen and Hermes 1. Well done, Michael. But at the end of the day, that was really, and I'm slightly playing devil's advocate here, and by no means demeaning his extraordinary job in front of the Privy Council. It was a question of interpretation. What had the parties intended by their arbitration clause? And interpreters are human. And Justice Bannister and the Court of Appeal decided, when interpreting the clause, that it wasn't the same interpretation as the Privy Council ultimately upheld. You've then got the other hugely important arbitration case for the jurisdiction, which is Sonera and Cukurova, and that deals with the enforcement of a convention award and does demonstrate, and that did go all the way to the Privy Council in one direction only, that arbitration will be upheld, the review process will be sparingly applied, and despite every effort by my clients, we got absolutely nowhere. There's a second aspect to Cukurova which possibly is leaving the door a little bit more open, and that's the question whether the court still has the jurisdiction to grant an anti-arbitration injunction. And you'll know that in Cukurova there were two competing decisions, and we never actually got to the Privy Council on that question, because we in fact lost the second arbitration that was competing with the first arbitration that we very much hoped that we were going to win. So as things stand, the Court of Appeal does have an anti-arbitration injunction in its arsenal, but that may get challenged one day. But I think even in looking at how the Court of Appeal did apply that interim relief, they did it in a very deferential way, and I just want to take a couple of minutes to quote from what they said, because I think it does illustrate the approach of the bench. And what they said was, and they're quoting the section of the Act about non-interference, Section 3.2b of the Act does no more than state the policy as to how arbitrations are to be viewed and governed in the BVI. with a clear prohibition or warning to the court in the seat of the arbitration not to interfere in the arbitration. This warning to the court, as a guiding principle, informs the court's approach to an arbitration, be it domestic or foreign. So there you have clear judicial recognition at high level of the guiding, overriding principle. And the court then goes on. A clear distinction should be drawn, however, between interference with an arbitration on the one hand and restraining a party who may be using, be it an arbitral process or a court process, in a manner which may be said to be vexatious or oppressive and abusive of the court's own process on the other hand. Now that's the traditional test for the grant of an anti-suit injunction. So the court is saying, we've got the message loud and clear, but we're still going to protect the process, be it litigation or arbitration, from abuse. And as Michael said, Anzen involved a clause in a shareholders' agreement. We're very used to shareholder disputes being litigated. I suspect we've all been involved in ongoing Russian oligarch sagas from time to time. But there's absolutely no reason why a shareholder dispute should not be arbitrated. Michael also mentioned trusts. Now, the BVI has a very important place on the offshore trusts arena. And I can say, as somebody who's been going to trust litigation conferences for decades, arbitration of trust disputes has been a hot topic throughout that entire time. There are specific challenges. How do you actually get an arbitration agreement signed? How do you bind beneficiaries who are not going to be born for the next 90 years? How do you secure approval of compromises where minor beneficiaries are involved? But there is an enormous appetite to bring the confidentiality of the arbitration process into the trusts arena. Mediation works, but only to a degree, and doesn't quite offer what the parties want. So I'm looking forward to hearing far more from Hélène in the future as to what STEP has up its sleeve on that topic. The roster of arbitrators that the IAC has put together is phenomenally experienced, extensive, and I think quite a lot of them speak more than one language, but there we are. But it is important to emphasise that that roster does include local arbitrators. We're not even being cut out at that stage. We are recognised as arbitration experts, and we can take appointments. And I think that experience and that expertise will deliver the cross-cultural sensitivities that the parties want. And I was reading an essay by Joshua Carton yesterday, and he was talking about a Swiss arbitrator, and saying that a Swiss arbitrator would actually have no difficulty whatsoever saying to a Swiss party or a German party, look, this arbitration isn't really going very well, you really need to consider settling it. But if they were speaking to an Australian or an English party, they would find it, and I quote, totally outrageous for the arbitrator to be interfering in that way. So that sensitivity is something that we all need to be astute to as well. I don't think I need to say anything at all about the facilities. We've all been enjoying them. I'm drawing to a close, and I had the privilege many years ago of working with Julian D.M. Liu, who was a partner in the litigation team at S.J. Berwin, where I worked. I don't think I can do any better in my conclusion than to quote an observation of his, that arbitration has stood the test of time because it has served its users well. It has met the needs of those who have considered the national courts unsuited to their needs. And it's those needs that we must have regard to as the BVI takes its place in the arbitration arena and competes for, and I've no doubt secures, its rightful place on the arbitration network. And to the scoffers, or at least the remaining scoffers, I would say this: don't get wound up about all of this. For every one of the factors that makes arbitration so appealing to some people, those very factors are going to make it unappealing to others. The choice of arbitrator, the cost, confidentiality, flexibility. There are going to be those who are absolutely appalled by all of that. There will remain those parties who want their disputes publicly aired. They don't want to pay for their judge, let alone 3 or 5 of them. They don't care care if their judge only speaks one language, and they want to drag things out to the Privy Council if they can, because that is their legal right. So nobody's lunch is going to be cut. We're hopefully going to be offering diners a choice of 2, both Michelin-starred meals, top-notch international commercial litigation and top-notch international commercial arbitration. They can both be served from the same kitchen, they can both be cooked by the same chef, and they can both be delivered by the same waiter and waitresses. So let's work together to build an arbitration culture on the very solid foundations we already have, with the benefit of the experience from other jurisdictions which my co-panelists have spoken about. Thank you very much for your patience, and scoff no more.
Well done.
Thank you so much, Arabella. I think that's what's described as an incontrovertible statement. Nonetheless, I will open the floor to questions. We have about 5 minutes. Is there anything? Anyone? Anybody? No?
Okay, I'll ask a question.
Since you brought the mic.
My question's for Natalie. In 2010, I attended the ICA conference in Rio and noted that there was a real push to promote arbitration in Brazil from every sector of the arbitration community. And I remember saying to myself at that time, I wonder if this is going to work. Is it going to make a difference? So I was very interested when you started this morning to see what's happened since 2010. Mm-hmm. I noted 2 things. One, there was a bump in 2010, and another thing is that there was a dramatic increase in the chart from 2010 until now. So and I think that it might tie into what Arabella was saying about culture. Do you think that that had an impact in Brazil, and what might that say to us in BVI as to what benefits might come from the arbitration community coming here and the BVI being introduced to the arbitration community generally?
It's an excellent point, Murray, and I think in some ways sort of the last part of your question began to give the answer. The one dimension perhaps of the identifying the drivers that I hadn't included in my presentation is what the response and the role and the involvement of the international community outside of Brazil has been. And I agree with you that I think in this decade, so since sort of the late 2000s and through 2010, what we've seen is increased participation by international arbitral institutions. So for example, the ICC has just opened its first office in Brazil. The CPR, the International Institute for Conflict Prevention and Resolution, has just opened its office in Brazil. More and more international law firms have, over the years, co-counseled with Brazilian firms. So you are having a greater integration of Brazil's once nascent and now quite strong local arbitration community into the broader international arbitration community. And I think that that's critical because certainly many of the largest disputes, many of the repeat users of arbitration continue to have very strong relationships with those main arbitral institutions, with many of the international law firms. So to be, I think, a viable international arbitration hub and to have a truly strong, with deepening roots, local arbitration community, you have to have that connection with the international, the rest of the international community. And as many people have said, if you look around the room here, if you look at the board of the International Arbitration Center, if you look at the speakers who have come, it is a remarkable testament not just to Hurricane Dawn, but to the BVI itself, and to sort of those who are already viewed as being sort of well-known and well-established international arbitration practitioners.
Good, thank you. Stuart.
Thank you. Can I just make 2 brief comments to support the theme of building an arbitration culture in the Caribbean? Firstly, it hasn't been mentioned, but there is another project underway, which I'm not involved in, but I know others are, and that's the Impact Justice Scheme, which is being done through UE, funded by Canada, I think. And that scheme has been developing a variation of the UNCITRAL model law for adoption throughout the Caribbean. One of the problems within some of the jurisdictions in the Caribbean is the very outdated local domestic law that there is, arbitration law. BVI is not suffering from that. Jamaica is very close behind with the introduction of the new UNCITRAL model law, hopefully this week. But a number of the other jurisdictions, such as Trinidad and St. Vincent, where I practice, it's very outdated. So that impact project is underway, and with the aim of adopting the UNCITRAL model law throughout the English-speaking, at least, Caribbean region. So I think that is another demonstration of the developing culture within the Caribbean. The second comment that I wanted to make, and this is picking up on what John Bassie said, and also Arabella, and in some ways to address the scoffers. Might I suggest that the scoffers are probably not actually in this room. So what we need to address is the scoffers that are outside of this room and bring them into the room. And one of the ways that we are trying to do that in the region is through the Chartered Institute of Arbitrators. And Arabella, I know that you're chairman of the BVI chapter, which is great. Here we have Shan, who is chairman of the Caribbean branch. I'm fortunate enough to be the vice chairman. We've got other members of the committee here. And we've been running courses this week here to spread the word and to support the arbitration centre here. And the Caribbean branch is growing. We've got some 160 odd members now within the Caribbean, and that is growing. And we are promoting, if you like, from the bottom up, and creating awareness and capacity for at least domestic arbitration, and awareness of, and then leading on, hopefully those people that are trained by the Chartered Institute will go on to become international arbitrators, certainly within the region and hopefully internationally as well.
Thank you. One more question. Anybody? No? Well, I thank you all for coming to this first morning session. Oh, sorry, Michael.
No. I just want to state something which is so obvious it hasn't been stated, which is if you're going to have arbitrations, you have to incorporate arbitration clauses in your contracts. And not just in your contracts, but in your articles of association of your companies and so on. And one of the messages you've got to get out there to the scoffers is to persuade clients to put arbitration clauses in all of their contracts and in their company constitutions as well. That's something that has to be done.
Can I add to that as well? Because not only do you need to do that, but you need to get the lawyers to use it when it's in there. Because one thing that I've heard is that even though there may be an arbitration clause in the contract, sometimes it's not used. And sometimes, even though it's there, because there is some comfort amongst lawyers about the system that they're used to, litigation, that they in fact don't use that clause. So it's a combination of having the clause there, which is obviously vital, and then making sure that it's actually used.
Okay. Thank you. Again, Michael, there is some pressure from our force of nature to incorporate the clauses. Dawn has been circulating model clauses and has been urging people to consider incorporating the clauses as you have suggested. Again, thank you very much for participating. Thank all of you. Thank my panelists. It has been very instructive and very aspirational, but in the end, very incontrovertible. Thank you very much.